of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This meeting of the Honorable Senate of Jamaica for October 15th, 2021 is called to order. And before proceeding with the business of the day, there is a request which was put in the proper form and order to the Clerk of the Senate and refer to the Senate for my approval to have Senator Campbell Rodriguez join the Senate virtually. She is in fact on business in Monrovia, Liberia, which makes her the most distant member of the Senate thus far. So I ask the approval of the Senate for her to join the session virtually. Do I have your approval? Thank you very much. Welcome from Monrovia, Senator Campbell.
Thank you, Mr. President.
Okay, I hope that you are well.
I'm well.
Thank you very much. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following. Ministry papers number 67, 68, and more to that. Excuse me, there's something there I'm missing. All right. Ministry paper number 67 of 2021 entitled National Policy for the Environmentally Sound Management of Hazardous Waste. And Ministry paper number 68 of 2021 entitled the Casino Gaming Commission Annual Report for the year ending March 31, 2021. And white paper number 2 of 2021 entitled the National Policy for the Environmentally Sound Management of Hazardous Waste. Annual report of the University of Technology, Jamaica for the year 2018-2019. Annual report of the Tourism Product Development Company for the year 2017-2018. Special audit report on the Joint Committee for Tertiary Education. The Auditor General's review of the fiscal policy paper for the financial year 2021-2022. Interim report. And for information, report of the Joint Select Committee appointed to consider and report on the motion for consideration of a proposal that the City Municipality of Portmore becomes the 5th parish of Jamaica. Ministry papers number 70, 71, 72, and 73 respectively, under the law reform zones of special operations, special security, and community development measures for 1. the Norwood Community Zone Social Intervention, October 8, 2021. 2. the Augustown Community Zone Social Intervention, October 8, 2021. 3. the Greenwich Town Community Zone Social Intervention dated October 8, 2021, and the Denham Town Community Zone Social Intervention October 8, 2021, and last but not least, the Mount Salem Zone Social Intervention October 8, 2021, and the Law Reform Zones of Special Operations, Special Security and Community Development Measures in respect of the Denham Town Community Zone Extension of Period of Operations Number 5 Order 2021, the Mount Salem Community and Environments in the Parish of St. James Extension of Period of Operation Number 5 Order 2021, the Greenwich Town Zone Extension of Period of Operations Number 5 Order 2021, the August Town Zone Extension of Period of Operations Number 5 Order 2021, and the Norwood Community in the Parish of St. James Zone Extension of Period of Operations Number 2 Order 2021, respectively, and their respective resolutions.
Thank you, Madam Clerk. Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 12th day of October 2021, the House of Representatives agreed to the Senate amendments to a bill entitled An Act to Make Provision for the Prevention of Sexual Harassment and for Connected Matters. I also have the honour to advise the Honourable Senate that on the 13th day of October 2021, a bill entitled An Act to Provide for a National Identification and Registration Authority for a National Identification System and for Connected Matters was passed in the House of Representatives. Signed, Marisa Dalrymple Philibert, CD, MP, Speaker of the House of Representatives.
Mr. President, I signify my willingness to take charge of the bill.
Thank you.
A bill shortly entitled the National Identification and Registration Act 2021, read a first time.
Mr. President, I beg to give notice of second reading of the bill.
Thank you, Minister. Petitions, papers, reports from committees, questions and answers to questions. Senator Morris, I received some questions, but I'm going to ask you to take them next week so I can have an opportunity to peruse them. I just got them this morning.
Okay, if it's so.
But I do believe, however, that Minister has a response in relation to a previous set of questions.
Yes, Mr. President, and in so doing, I respectfully ask the Honourable Minister of and Leader of Government Business if she could kindly answer the questions standing in my name on the question paper.
Oh, I'm sorry. I'm sorry. Just to recommit notices of motions given orally. Sorry, Senator. Yeah, notices of motion. I'm sorry. Notices of motions given orally. Sorry.
Thank you, Mr. President. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move. Whereas on the 9th day of October 2021, this Honourable Senate appointed a special select committee to sit jointly with a similar committee appointed by the House of Representatives to consider and report on private bills, and whereas on the 28th day of September 2021, the House of Representatives, by motion taken and approved, referred a bill shortly entitled The Sisters of Mercy of Jamaica, British West Indies Validation, Indemnification and Amendment Act 2021 to its Private Bills Committee for consideration and report. Be it resolved that the Private Bills Committee of the Senate, in keeping with its terms of reference, sit jointly with the Private Bills Committee of the House of Representatives to consider and report on the aforementioned bill. Mr. President, I further beg to give notice that at a later stage today I will move for the suspension of standing orders to enable me to take this motion.
Thank you very much, Minister. And now to questions and answers to questions, so that the comments which I made earlier would stand. And I believe, Minister, you have a response to questions asked by Senator Morris on October. I'm sorry. Minister, you would have the dates. You can respond, please, the dates when the questions were asked.
Yes, thank you, Mr. President. They were due to be taken on Friday, October 15th, but we did not sit on that day, and they have subsequently been provided by the Ministry of Health. So, Mr. President, in answer to the question, is the Minister aware that the Centers for Disease Control, CDC, recommends that persons with disabilities should be treated as a priority group in the delivering of vaccines? The Ministry of Health and Wellness is unable to find the referenced recommendation as stated above on the CDC's website, but would welcome receipt of a copy of the reference or a link to the relevant web page. 2. If the answer to part 1 is in the affirmative, will the Minister please indicate whether the Ministry of Health and Wellness prioritized persons with disabilities in the early stages of its vaccination program? The answer to part 1 is not in the affirmative, but in keeping with international recommendations and the guidance from the World Health Organization, which Jamaica uses to guide its programs and interventions, the priority groups at the beginning of the COVID-19 vaccination rollout were healthcare workers, persons aged 60 years and older, institutionalized persons, non-health frontline workers. Persons with disabilities who were part of these groups would therefore have been included. 3. What were the efforts made to include persons with disabilities in the vaccination drive? A protocol to treat with persons with disabilities has been written. The Council for Persons with Disabilities, social workers, community health aides, parish councillors and community-based workers, along with agencies that treat with persons with disabilities, were engaged and asked to provide a listing to assist with locating such persons. The Jamaica Society for the Blind worked with the Ministry of Health and Wellness to transport persons to vaccination sites. Provision was made for the caregivers to be vaccinated at the same time. And in addition to persons accessing all the vaccination sites and being given priority, specific sites or specific times have been allotted to inoculating persons with disabilities. Examples at the Portmore Health Academy and Mona Aging and Wellness Center, at the Sandals Inn and the Type 5 Clinic in Montego Bay, Independence Park in St. Elizabeth, and Mandeville Regional Hospital, to name a few. Can the Minister state how many persons with disabilities have been vaccinated? No, that data is not captured. Can the Minister provide information on the vaccination rates among persons with disabilities by gender and rural versus urban status? No, that data is not captured. And 6, can the Minister please indicate what current strategies are being used to reach those persons with disabilities who are confined to their homes due to their disabling conditions with the vaccines? There is a registration tool on the Ministry of Health and Wellness's website for all shut-in persons. Once persons register, the Ministry of Health and Wellness will visit and inoculate. It was launched at the COVID Conversations, I think that should be a COVID Conversation session, live tweeted and shared on social media, as well as announced by press release. Persons can also call in to 8881-LOVE number to register for this service. The Ministry is currently sending out the information by email and is preparing mainstream media advertisements. The regional health authorities are aware and have also been asked to reach out to private doctors in their respective parishes.
Thank you very much, Minister. Morris, I recognize you from a seat other than your own.
Thank you very much, Mr. President. Okay, thank you. Mr. President, I just have a few follow-up observations observations that I would like to make.
Yeah, I'm happy that you refer to them as observations, because I don't know if the minister could deal with follow-up questions as such.
Yes. In light of the situation as well, Mr. President, that I don't have the responses in an accessible format, and so I would just be moving via memory and the clarity in which the minister spoke. So, Minister, you indicated in terms of question number 1 that the ministry said that they weren't aware of the information relating to the CDC website, and they would be happy for such reference. But I'm certain that earlier this year, when I was doing my research and I looked at the CDC on the internet, that was one of the recommendations that came from the CDC. So I wouldn't have made such reference without coming across that on the internet. But also you indicated that the ministry takes its guidance from the WHO. So it could very well be that the ministry wasn't paying attention to those recommendations from the CDC, and hence not seeing the community of persons with disabilities as a priority group. But in any case, the WHO also recognizes that persons with disabilities are a particularly vulnerable group, because they too have various diseases that could be considered serious and injurious in light of the COVID pandemic, and so they are a priority, and there's a number of documentations that the WHO has put out in terms of the treatment of persons with disabilities in terms of vaccination. Minister, you said that there is a protocol that was developed. Is this a written protocol, or is this, and well, I'm bearing in mind what the president said, that you might not be able to respond. But I would want to find out if, was it said that it was a written? There's a written protocol. What has become of those written protocols? Because, I mean, certainly I haven't seen any such protocol, and I have reached out to the Ministry of Health on several occasions about this matter, and I haven't been apprised of such protocol. I take note, Minister, that we are not able to respond to the particular question of the number of persons with disabilities who have been vaccinated. And this is very unfortunate, because, I'm certain that when the Jamaica Council for Persons with Disabilities and the government...
it's an unusually long run-up for a question, or a follow-up question, Senator. But I just wanted to bear that in mind.
Well, I did make it known that I was going to make some observations, right? And the president indicated that the minister couldn't answer some of the questions. So Minister, in light of the unavailability of the data for where vaccination of persons with disabilities are concerned, it just indicates that the group of persons which are very vulnerable in our society wasn't a priority. Because if they were a priority, they would have been featured in the in the data capturing mechanism. And I think that this matter needs to be corrected, since we have such low levels of vaccination take-up. We should correct that situation post-haste and make sure that in going forward, persons with disabilities are captured in the data and also prioritized. May it please you.
Minister, any response?
Mr. President, the questions that were posed have been answered. I did take note of the question raised by Senator Morris in respect of the protocol in particular. And should he wish, I would be happy, of course, to request a copy be sent to him by the Ministry of Health and Wellness, as his efforts, as he has indicated, were unsuccessful.
Okay. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sittings of the Senate. Motions for leave to introduce bills. Presentation of bills without leave on the Senate first obtained. Public business. Minister.
Thank you, Mr. President. Mr. President, I now move for the suspension of standing orders to enable me to take the motion, notice of which I gave earlier.
The question is for the suspension of the standing orders in order to allow for the statements to be, that was read earlier. Those in favor?
Aye.
Those against? The ayes have it.
Mr. President, the question is that the motion be approved.
Question is for the motion to be approved. Those in favor? Aye. Those against? The ayes have it.
Thank you, Mr. President. Mr. President, it is intended today to deal with the amendment to the Companies Act in respect of the ability to hold annual general meetings by different formats. And it is also intended thereafter to take the disabilities regulations in that order. Mr. President, without further ado, I therefore wish to commence the debate on the Act to amend the Companies Act.
Proceed, Minister.
Thank you, Mr. President. Mr. President, in order to manage and curtail the spread of the COVID-19 pandemic, the disease rather, the government has had to act decisively in the interests of public health and safety in many respects. Orders under the Disaster Risk Management Act have been issued on several occasions to maintain restrictions on public gatherings, including the requirement to maintain a physical distance of 6 feet between participants at such gathering. These have, of course, affected public activities in both the public and private sectors, but have been necessary because, of course, the virus moves only when people move, and accordingly, the movement of people and their gathering has had to be curtailed. In the private sector, the holding of annual general meetings by companies has been particularly affected, and as mandated by Section 126 of the Companies Act, a company must hold an AGM within 15 months of their last meeting. Compliance with this requirement has proven difficult for companies which have more shareholders than the number of persons permitted by the disaster risk management orders for public gathering. As a result, some companies have been seriously challenged to hold the AGMs in compliance with the Act. Without permission from the Supreme Court to hold a meeting with a mixed modality, companies have been left open to the possibility of being held in breach of the requirement for holding their AGMs. As we work to be responsive to various issues arising throughout this pandemic, The government will now, therefore, through the amendments contemplated today, provide the option for companies to vary the modality of their general meetings as a rule rather than an exception to the rule, and of course by simplified process. Mr. President, with these considerations in mind, a decision was taken to amend the Companies Act in order to A, provide for the holding of any general meeting, such as an annual general meeting or an extraordinary general meeting, as a virtual-only meeting, that is, completely electronic, or a hybrid meeting, that is, a combination of in-person and virtual, where this is not expressly prohibited by the articles of a company. So rather than in circumstances where articles have been silent, the presumption has been that it's not permitted, and this is where the difficulty has lain. So now it is intended by this Act to allow for this permission across the board, once it is not expressly permitted, because that would trigger another type of process by the company in respect of its articles. B, Mr. President, these bills provide for conditions necessary for the holding of hybrid meetings or completely electronic meetings, which ensures participation of all members in attendance, and it will seek to empower the registrar of companies to grant an extension of time for the holding of an AGM or on the application of a director of a company or any member who is entitled to vote at a meeting where an order has been made under the Disaster Risk Management Act or a proclamation has been made by the Governor-General declaring a period of public disaster or a period of public emergency under Section 20 of the Constitution. And we just want to make clear here, Mr. President, that also circulated are two amendments, and one of the amendments will also provide for the registrar of company to allow for a shorter period of time. So in Clause 4, which provides for the new Section 133F2, and that is a clause to be amended, that's where it requires a notice for a postponement of the AGM to be given no less than 30 days before the date on which the AGM is due to be held. But certainly, if a disaster were to occur within that 30-day period, then that would be problematic. So the registrar is being given the power to allow for a shorter period of notice to be given to request postponement. So that has been circulated. Mr. President, I'll just seek to briefly discuss some of the features of the bill by clause. Clause 1, of course, short title and construction of the bill, indicating that it should be read in conjunction with the Companies Act and all amendments thereto. And Clause 2 provides amendments to Section 2 of the Principal Act. It inserts new key additional terms, the meanings to be attached to them as they are used throughout the bill, including the terms such as electronic communication system, hybrid meetings, in-person meetings, and virtual-only meetings, to which we have all become highly sensitized over the last, I would say, 20 months. Mr. President, the clause further amends Section 2 by inserting a new subsection 10, which allows for persons to be present at a general meeting and cast votes by hybrid or virtual-only means, and for such persons to count as part of the quorum. Subsection 11 is also being inserted, a new subsection 11, to stipulate that the provisions of the Act shall apply to hybrid and virtual-only meetings with any necessary modification. Clause 3, Mr. President, amends Section 30 of the Principal Act, and here it expressly permits the attendance and participation in meetings, including voting, by both in-person and electronic means. And Clause 4, which is I would say a large portion of the Act, inserts new sections 133A through F to be inserted in the Principal Act. 133A speaks to the permission to hold hybrid and virtual-only meetings if satisfied that attendees will only be able to attend and fully participate. Will be able to attend and fully participate in the meetings. 133B speaks to the hybrid and virtual-only meetings having full effect as if the meeting were held in Jamaica as an in-person meeting. And this provision won't be applicable if the virtual only or hybrid meeting is not conducted in a manner to enable full participation and communication between all attendees. So it is still critical that all of the requirements for a proper meeting to be met, and the intention is to facilitate using technology but not to relax the requirements for such a meeting. So full participation and communication has to be verified. Section 133C speaks to the permission for a document, including the notice of meeting, to be delivered by electronic means in the case of hybrid and virtual only meetings, and it states what is required to be included in the notice. 133D speaks to verification of identity and attendees. It allows the company to establish procedures and restrictions to secure the conduct of the business of the hybrid or virtual only meeting, including verification of attendees and participatory acts such as voting. So you must have clear procedures in respect of this functionality. 133, Mr. President, speaks to the fact that where hybrid or virtual only meetings are being held, and during the fact that during the meeting, if attendees cease to be able to participate in the meeting in such numbers to the effect that quorum is not met, so if the connection goes, if power goes, anything that ceases the connection or the ability to participate in such numbers that quorum is not met, the chairman shall adjourn the meeting to a date and time agreed by the attendees who are able to fully participate, unless the disconnected attendees are reconnected within a reasonable time. So there is some flexibility there, but there's a recognition that being quorate at the start of the meeting does not carry through. The meeting must continue to be quorate throughout, save for any reasonable disruption, to allow for full participation of members. 133F speaks to the application for extension of time, and as I mentioned earlier, it also speaks to the reduction of time where something may have occurred in a period closer to the scheduled date of the AGM, requiring its postponement. So the registrar can make adjustments in that regard. And before I move on to clause 5, which deals with table A and table B, I just want to make note that 133A1 is also on the amendment sheet, and there it is being proposed that the words "unless the articles of a company otherwise provides," and substitute therefore the words "unless prohibited by the articles of a company." That is 133A, and again this is about the holding of virtual or hybrid meetings. So it's the express provision. It had been raised in the lower house, was to be considered, and is now being inserted in the bill. Thank you for allowing me that clarification. Mr. President, clause 5 deals with the related amendments to the first schedule. Table A, which provides for companies limited by shares, has been amended by the insertion of a new Article 47A, which provides for companies to now include for the holding of annual general meetings by electronic means in their articles of incorporation. Article 50 will be amended to provide for notice of AGM to be served by electronic means and states when it is deemed to be served. Article 53 will be amended by inserting a new subsection 2 to stipulate that a person participating in the meeting by electronic means is to count towards the quorum. Article 61A is to be amended by providing other modes of voting where a hybrid or virtual only meeting is held, unless voting by poll is demanded. And Article 131 will be amended to allow for the service of a notice for a meeting by electronic communication means, including fax or email, with the written consent of the members and in accordance with the requirements for service of the notice. Table B is amended in all those regards as well by insertion of a new Article 8A, new Articles 11A and 11B, an amendment to Article 14 and an amendment to Article 23A. They all carry through in Table B. Mr. President, Clause 6 provides for the insertion of a new 17th schedule, which provides for the Form 26 to be used by companies to make an application for the extension of time for the holding of an AGM where an order made under Section 26 of the Disaster Risk Management Act, declaring the area in which the meeting was to be held to be a disaster area or threatened area, or a proclamation under Section 20 of the Constitution, declaring a period of public disaster or a period of public emergency, pursuant to the new Section 133F referred to earlier. Just probably need to confirm with the technical team whether an adjustment would need to be made in respect of the amendment that circulated this morning, but that can be confirmed before committee. And Mr. President, that is in gross, the bill which is before us. The government is cognizant of our responsibility to maintain an enabling business environment while managing the pandemic, Mr. President. It is important for our economic recovery. The bill allows companies to leverage technology for business continuity and legal compliance while preserving shareholders' rights and safety. Ultimately, this helps to keep companies providing services to the people of Jamaica. It helps keeping people employed, and therefore it in turn helps support the livelihood of families. And this in turn supports our mandate of building back better and stronger. In this context, Mr. President, I submit the Companies Amendment Act 2021 for members' consideration and approval. I thank you.
Thank you, Minister. Senator Fraser-Binns.
Mr. President, you would have seen me talking with the leader, because we are both of the view that the amendments before us today require not a lot of talk, because they're so relevant, so important, and we on this side certainly give our complete support to the proposed amendments to the Companies Act. As the Minister quite rightly said, that recent or perhaps not so recent events have really caused us to look at how we do business. And it is true that, is this better? Yes, recent events and perhaps not so recent events have caused us to take a second look at how we undertake business generally, and specific to this purpose, how we have our annual general meetings. Senator Webley, given the office that you hold in another place, you understand the importance of these amendments, and I know that you undoubtedly will give them your full support. Mr. President, what this has done is that it has put to rest once and for all any questions whether or not these meetings that have been held or these meetings that will be held will be constituted and thereby valid. I mean, we are very much aware that prior to this there were some questions, and the matter, I believe, went to the Supreme Court and the determination was made. And these amendments have sought to put in law that, in fact, hybrid meetings, virtual meetings, pursuant to the DRMA, well, activities under the DRMA are legal. My only concern, Minister, has to do with the proposed amendment at clause 133F. Well, the amendment to the new 133F, which would be the amendment to section 133. And it is that the hybrid, as I understand, and please correct me if my understanding is incorrect, but it is my understanding that the holding of meetings, whether virtually or hybrid, is contingent only upon activities under the DRMA. And if my understanding is correct, I wondered whether we could not, in keeping with the times, outside of COVID, but the fact that the world has become so technologically advanced, and people are no longer sitting at desk and having meetings, but you can stay wherever you are in the world and have meetings. And the benefits to be derived from having virtual meetings outside of a pandemic as this, whether we would not want to address our minds to having this done even outside of pandemic or outside of events under DRMA or Section 20 of the Constitution. So that is the only concern I have, but it does not take away from my wholesome support of the bill. And with that, Mr. President, we on this side give our support, and I assure you we will not be long so. Thank you, Mr. President.
Thank you, Senator Fraser-Binns. That was quite a short presentation, but good. Senator Webley.
Mr. President, my contribution will be brief, similar to Senator Fraser-Binns. Mr. President, I rise to wholeheartedly support the Companies Act Amendment 2021, and I've broken it down into two sections, which I think the leader of the House captured very nicely. The first is that it will allow companies to host annual general meetings in a virtual or hybrid format. And secondly, and very importantly, it will allow the registrar of companies to grant an extension of time for the holding of an annual general meeting. So there's a certain amount of flexibility built in these amendments. From where I sit, Mr. President, the bill will also address the uncertainty that was created whether hosting a virtual annual general meeting or hybrid general meeting was allowed under the Companies Act. So that has been cleared up. Mr. President, I think I need to really commend Minister Audley Shaw, and I was so elated when I heard him in Parliament sounding like the real man of yard, and I want to wish him a speedy recovery, but I was so happy to see him getting back to his form. But we need to really commend Minister Shaw for responding to the concerns of stakeholders. The truth is, many companies face challenges to host their annual general meetings, and as was said before and reinforced by Senator Fraser-Binns, primarily because of the Disaster Risk Management Act, which imposes a certain amount of people allowed in the room and social distancing and so. And as all of us would know, shareholders' participation or owners of the company participation is the single most important part of any AGM. So I think it is extremely important that that would be covered. What happened before, Senator Allen, is that companies, public listed companies, we would have to go to the court on a case-by-case basis to seek an exemption to have our AGM in a virtual or hybrid format. And I can tell you, for the lawyers in the House, like Senator Scott Motley, as we would say, it's not cheap. It can cost you up to $1 million Jamaican dollars, sometimes more, to go through the whole process to get that exemption. So this is a welcome amendment that obviously will save some cost to the public companies. The truth is, colleagues, that we're living in a world that is very unprecedented and unpredictable. And I don't think the greatest of us, of experts, Senator Floyd Morris, can say with a definitive position of when this pandemic will end or what the world would look like post-COVID-19. But one thing we know for sure, it's not going to be the same. And having said that, the health and safety of all stakeholders must be of paramount importance. You know, that's the headlines, the health and safety of our stakeholders. So the legislation is therefore timely in terms of moving our Companies Act forward to host general meetings in a format which will ensure safety for all stakeholders while supporting business continuity. Senator Fraser-Binns is right. As the CEO of a publicly listed company and a chairman of another publicly listed company, I must confess to this honorable House that I had my serious concerns of how an AGM would have been held in this pandemic, because a number of companies were postponing. I always use this term, this phrase to my colleagues of where there is a crisis, there is an opportunity. And I'll share more with you about that. So the first thing that we did, Mr. President, is we did research in terms of, is there technology that will support hosting an AGM that all shareholders can participate? And Senator Morris, there are basically three legs to that. The first one is that the software must or should have audio and video facilities, and we got to check. The second one is that it must have chat and messaging tools within the software program that is being offered. And then the third one, it must have sharing capabilities. In other words, when the CEO or the CFO stands up, he should be able to share the presentation that all shareholders can see. And most importantly, it must have voting capacity. Must have voting capacity. Well, you know, the great news is, and I'm very proud to stand up and say to all of you in here, we found that software. It was owned by a Jamaican company, developed in Jamaica, and the intellectual property is owned by that company. So we find what we needed right here. And that's why I always say that Jamaican people are the brightest anywhere in the world, right? This young man developed this software to facilitate it. And I tell you something, we also did benchmarking because Nestle and Coca-Cola had their AGM virtually. And when we compared, Senator Allen, what we were offering in terms of the technology developed by a Jamaican, it was just as good as any Coca-Cola or any other company in the USA. And I really felt very, very pleased about that, because I was concerned of where we're going to find this technology, President. I don't want to say it publicly, but I'll tell you after. But I'm saying to you that the talent is here to do this kind of thing. The other thing that was very pleasing to me under the Senator Floyd Morris, Dr. Floyd Morris, was that the company that I work for, we have shareholders in 24 countries. So when you hear the saying that Jamaicans are everywhere, it's not a joke. These are Jamaicans owning shares in the company that I work for. And at the AGM, this was the first time in our company's history that the diaspora who have shares in our company were able to participate in the AGM. Where there's a crisis, there's an opportunity. So we had Jamaicans at our AGM from Italy, Australia, China, and Japan, who participated and asked questions about their company, because they are the owners from so far. So this new world that is evolving, right, is just going to be unbelievable in terms of how technology is going to be used. And my personal opinion, President and colleagues, we're not going to go back to having an AGM only that you have to be physically there. I think the hybrid is going to become the norm. And when you have Senator Johnson Smith, leader, the diaspora, which you will appreciate, participating in the capital markets because they can now be more involved in the AGM, you can quickly recognize that it's going to be a positive for the equity market in Jamaica and the Jamaica Stock Exchange. So this amendment is just brilliant, not only because of the pandemic, but looking at the bigger picture of the future. The other point that I'd make also is that we are, I won't use the word dependent, but foreign direct investments, which has been averaging about, pre-COVID, about $650 million US over the last few years, on an average. I'm absolutely sure that these foreign investors here will appreciate that they now can have a virtual or hybrid meeting having invested in Jamaica. And this should also apply to the international business companies. Because what we're saying to the world, by these amendments, we're saying that we're open for business. And this is now a more business-friendly environment that we're operating in. So as I mentioned before, colleagues, senators, the business landscape in the world and in Jamaica has changed. And it will continue to do so as we move forward. We will move forward to what will be considered a new normal. And none of us are really sure what that new normal will look like. But we have to be agile as we move forward in terms of this new normal. So when I reviewed the amendments, I said that these amendments are basically a reminder that we need robust legislative mechanism in place to respond in an agile manner to, first of all, the new business requirements in the new world, and second, to ensure that we maintain best practices in good governance, which are constantly changing in response to social, legal, economic, and the regulatory climate. For instance, over the last few years, I've noticed in terms of reading annual reports that public companies overseas are required to have a discussion included, and you will appreciate this, Senator Fraser-Binns, a section called Economical, Social, and Corporate Governance, ESG, in their annual reports and report to their shareholders. And what ESG really is, it's a criteria or a set of standards for a company operations that socially conscious investors, right? You talk about the CSR, that socially conscious investors use to screen potential investments. So the days of investors, looking at your balance sheet and your P&L and making an assessment of the strength of your company and how you are doing, it just forms part thereof now. They are looking at your social consciousness, and it has shown when you do your research with the analysts that those companies, in terms of relative values, are more than others who only focus on the balance sheet and the P&L. So investors are increasingly applying these non-financial factors as part of their analysis process to identify a company's material risk and growth opportunities. Mr. President, based on my research, and hopefully I'm not too off, but the last time a significant change was made to the Companies Act, in other words, a proper overhauling, was 2004. That is a long time ago. That is, in fact, that's 17 years ago. So I really want to support Minister Shaw again when he made a statement in this honourable House that there's going to be a next phase of amendments to the Companies Act. This is just a start in terms of the process. And he went on to say that is going to strengthen the efficiency in relation to incorporation of companies, administration of companies, and proceeding meetings, and very importantly, very, very importantly, deterrence against companies being used for money laundering and other illicit activities. Very, very important. Mr. President and colleagues, there is one issue that has surfaced since this amendment, and it has come to me in a number of ways, that I believe, and I will speak to Minister Shaw and others on it, that in the next round of amendments, I want to suggest that we look at section 157(2) of the Act, which requires the auditor's report to be read at a company's general meeting. And let me just give you a quick background to that. So a new set of international financial reporting standards were published by the International Accounting Standards Board in 2017. As a result of these changes, affecting the auditor report have expanded, the auditor's report have expanded materially. So when I started off as a CFO, Senator Scott Motley, the auditor's report was 1 page. And the auditor would get up in your AGM and read it, but it's 1 page. Since these changes here now, right, is no less than 9 pages. And I can tell you, the print type for those 9 pages is small. In other words, what I'm saying to you, as part of an AGM, the auditors stand up and read 9 pages, which consumes a significant amount of the AGM's time, anywhere between 40 minutes, sometimes an hour, depending on how fast the auditor can read. As I said before, Mr. President, I'm an accountant by profession, and I believe firmly that in the interest of transparency and accountability, that shareholders should have the information available for them to ask questions. So I think that we can find a middle ground where we create efficiency in the administration of the meeting while ensuring shareholders' rights are not negatively impacted. But I can tell you, with the auditor standing up there for an hour or 40 minutes reading, in my mind, that's not a very efficient way to use your time in an AGM. I would like to suggest going forward that we look at the UK standard, and it's an international reporting standard by the UK, where the approach for the auditor's report is to be treated the same way as the financial statements. This means it is laid at the AGM and is circulated before when the notice has gone out, and is taken as read. It is taken as read, bearing in mind that the reports, as I said before, were previously published in their annual report. I've also seen legislation where an abridged or a shorter version is actually read by the auditors, and that can cut but the full thing is published, but the actual reading is an abridged version, which will take probably 10 minutes, and the auditors will be there to answer the questions. I think in terms of efficiency and moving forward, that is something that we need to consider when we're looking at further amendments of the Companies Act. And I'm speaking as a CEO of a public company. So, Mr. President, in closing, again, I want to commend the government, and especially Minister Shaw, on being proactive in amending the legislative framework to allow for virtual and hybrid general meetings. I also want to support further amendments to the legislation to strengthen the business framework, to create efficiencies and a more business-friendly environment. I thank you, Mr. President.
Thank you, Senator Webley.
The leader, if she had any other speakers, but if you will permit me to make 1 or 2 observations of commendation.
Go ahead, Senator Scott Motley.
I too, as Senator Fraser-Baines has said, this side welcomes this piece of legislation. It is not only timely, but it has come in good time, because it has come shortly after the issues have arisen and the court has ruled. And I think that I want to commend the technical team for their alacrity in ensuring that this piece of legislation has come here. I particularly, Mr. President, appreciate the clause that takes into account the problems that we sometimes have in connectivity. And as you know, I am a rural person, and I always think about the availability of internet communication in rural Jamaica. And so I particularly like the fact that if there is any problem in the internet connectivity that disrupts the meeting, then the chairman has the option of adjourning the meeting and having it on another date. I like that. And I do also appreciate the clause which speaks to that if there is a failure, if there is any gap, then it allows for people to come back on stream and to rejoin the meeting. And I think that shows how much thought went into ensuring that the average person, the average shareholder, can really have a voice in these meetings. You know, Mr. President, as we sat here, I realized that one of our senators is in Liberia and can join us virtually, and that the Senate itself has been a forerunner in terms of encouraging persons to join these meetings virtually, that participation. It is, I think, unfortunate that although this legislation has come from the House, I am not aware that they also are able to participate virtually. And I encourage, Minister, that this be seen as a new way of being. As Senator Webley says, we don't know what will happen in the future, and we don't know if COVID-19 will be replaced by some other kind of pandemic. It is good that Jamaica leads in some of these matters. And Senator Webley, it does reassure those who want to invest in Jamaica that we are moving forward in the right direction. So, Mr. President, I encourage the other place to also join the Senate. I couldn't resist that, Minister, to also join the Senate in setting the tone for the future. It has been done in setting the tone for the present. I accept the correction. Mr. President, finally, I would encourage the team in the Ministry of Justice, which looks at reform of legislation, to take a look at other pieces of legislation which might benefit from similar amendments. Again, I commend them, and I thank you, Mr. President.
Thank you, Senator Scott Motley. Senator Goulding.
Mr. President, my remarks are really going to be quite brief and in support, Mr. President, of the bill and the amendments to the Companies Act before us, and also in support of the comments made by my colleagues who have spoken previously. And I just want to echo Senator Webb's remarks in relation to the circumstances that surround foreign direct investment in Jamaica. And Senator Webby, I can tell you from where I sit in a private capacity, we have a number of clients who are foreign individuals or companies who have partnered with local companies in Jamaica on various projects and different types of investment in different markets and sectors. And so at the time that the borders were closed, it was a real hurdle for them to engage in overseeing activities in Jamaica and in participating in decision-making, and particularly in official meetings like annual general meetings. So certainly from where I sit outside of the Senate, I too welcome the amendments before us. And I welcome it also in the capacity of us trying to open our minds, as Senator Scott Motley alluded to doing things in a different way. Sometimes I find that these initiatives, though they seem very logical and sensible, are resisted by the very people who are intended to execute them once the amendments like this come out of this, this chamber, and once the policymakers have indicated that this is the policy they wish to implement. There's still a slight resistance, particularly with the older members of our society, and I'm not beating up on my seniors who have a lot of wisdom to share, but are often a little unwilling to embrace new technologies and new ideas. And I put myself in that basket, Mr. President, because I see sometimes my young ones at home making attempts to do certain things with technology that I immediately want to shut down because I'm just not sure. I am not sure about it because I am not exposed to it, but they're quite adept at meeting with each other on different fora, on the computer, over the internet, talking to their friends in other countries, friends who have migrated. There's no loss of functionality. And so these amendments in the context of companies doing business in Jamaica, Mr. President, I welcome and I encourage those of us who are reluctant to embrace the technology to sort of try to open our minds to it. There are a number of other areas that I would love to see us moving into more virtual execution, certainly in relation to even obtaining a TRN, Mr. President. It's a difficult process. If you make a mistake, if you have somebody who is abroad, it is quite tedious. You have to send documentation back, and they have to FedEx it back because everything has to be original. You have to have notary public, etc., etc. And I know some of those processes can be virtually executed. I commend the driver's license renewal process in the Ministry of Finance. My husband recently sent me something indicating my driver's license was up for renewal soon. And it's a process that I don't have to go anywhere to do. So I want to commend, I believe it is the Minister of Finance who has responsibility, because I've been seeing him systematically eking away at making it easier to do business in Jamaica. And Mr. President, that's what this government committed to doing when they came into office in 2020, and it is happening. So I congratulate Minister Shaw on this initiative. Indeed, it was a quick turnaround. It was a most responsive to commercial entities who were asking for relief, and he has given the relief. And so, Mr. President, I want to commend him and his team, and I too want to support this bill wholeheartedly and commend it to the Senate. May it please you, Mr. President.
Thank you, Senator Goulding Campbell. Minister.
Thank you very much, Mr. President, and I thank all the members of this honourable chamber who presented this morning. And I think it's fair to say that we are all quite clear that this is a positive development for Jamaica, and it's a positive development for those doing business in Jamaica. I want to clarify in respect of the question raised by Senator Fraser-Binns in respect of the scope. I will admit that it was my very first question as well. Why aren't we doing this beyond and at an earlier stage? And on a closer reading, recognized, and I just confirmed with the technical team as well, that it does have general scope. It does generally apply to the ability to have hybrid and virtual meetings. What is circumscribed in respect of the DRMA is the power of the registrar to expand or shorten time for notice. That is only done in the context of DRMA orders. So it's for predictability, you would need some stability around the timing of meetings, and therefore that stands as a general rule, save when the DRMA or the constitutional provisions are called into effect. So while, again, so this is exactly one of the circumstances referred to by Senator Webley, that is that out of crisis comes opportunity, and that opportunity is being leveraged, while, as set out in the Memorandum of Objects and Reasons, the context of the commencement of this matter is based in the DRMA. The clear reading of what the bill provides at paragraph A is for, generally, the holding of any general meeting as a virtual only meeting, completely electronic, or a hybrid meeting where this is not expressly prohibited by the articles of a company. So certainly companies which have articles that prohibit may now proceed to amend their articles, and they would be covered by the law going forward as well. That would be their only procedural hurdle. So in that context, Mr. President, and also just making note that there is one small further amendment, and that is really to amend the Form 26 consistent with the change which we just made regarding the application to expand time for the holding of the meeting. Certainly we need to include in the paragraph noted at the bottom of Form 26, so this is in respect of Clause 6, include the words, after the words due date of the meeting, we would insert the words, or such shorter period as the registrar may determine, so that it maps back to 133F2, which we earlier amended to allow for that flexibility in time. So with that, Mr. President, I thank colleagues once more for their presentations and their support of the bill, and I ask that the bill be read a second time.
The question is that a bill entitled An Act to Amend the Companies Act be now read a second time. Those in favour? Those against? The ayes have it.
A bill entitled An Act to Amend the Companies Act read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. I put clause 1. Those in favour? Aye. Those against? The ayes have it. I put clause 2. Those in favour? Aye. Those against? The ayes have it. I put clause 3. Those in favour? Aye. Those against? The ayes have it. I put clause 4. Minister, you have amendments to clause 4.
Yes, Mr. President. There are 2 amendments, and they have been circulated on the list, but we could just read them as they're quite brief. In clause 4, the first amendment is in new section 133A1, and it is to delete the words unless the articles of a company otherwise provide, and substitute, therefore, unless prohibited by the articles of a company. So it changes the onus. And the second amendment, Mr. President, in clause 4 is in new section 133F2, where the amendment will be to insert immediately after the word held the words or such shorter period as the registrar may determine. And as explained earlier, this is in respect of the flexibility given by the uncertainties that could occur under the DRMA.
So I now put the new amendments to clause 4. Those in favour? Aye. Those against? The ayes have it. I put clause 4 as amended. Those in favour? Aye. Those against? The ayes have it. I now move on to putting clause 5. Those in favour? Aye. Those against? The ayes have it. I put clause 6. Those in favour?
There's an amendment, Mr. President, just read, and this is in the new 17th schedule, Mr. President, under 133F1. So this is Form 26, and in the note, paragraph 1 of the note set out below, the form must be submitted not less than 30 days prior to the due date of the meeting. Right after those words, after due date of the meeting, we would insert the words or such period as the registrar may determine, so it maps back, Mr. President. And just check. Or shorter period, Mr. President, as the registrar may determine. Such shorter period.
So I now put the new amendments to clause 6. Those in favor? Those against? The ayes have it. I put clause 6 as amended. Those in favor? Those against? The ayes have it. I put the title and enacting clause. Those in favor? Those against? The ayes have it. The question is that I do report that the bill as having passed committee stage with 3 amendments. Those in favor? Those against? The ayes have it. I do report the bill as having passed committee stage with the 3 amendments.
Mr. President, I ask for a third reading of the bill.
The question is that the bill entitled an act to amend the Companies Act be now read a third time. Those in favor? Those against? The ayes have it.
A bill entitled an act to amend the Companies Act read a third time and passed.
Minister?
Thank you, Mr. President. Mr. President, it is now intended to proceed with the actually, Mr. President, I just wish to ask for your indulgence and the indulgence of the Senate by seeking recommittal of reports to committees before we proceed to the disabilities regulations. It has been brought to my attention that there was a report to be presented which has implications, and I believe Senator Braham is to present that report very briefly, and because of a timing conflict, he has asked that it be taken now rather than at the close of the regulations. If I could have recommittal of announcements and subsequently a recommitment of reports by committees and the notices of motion, so that would permit us to take the report.
So the question is for a recommittal of announcements, reports from committees, and notices of motions given earlier. Orally, sorry. Those in favor? Those against? The ayes have it. And announcements. Oh.
Mr. President, I beg.
One second, Senator Brown.
Also laid on the table of the Senate today is the report of the Senate Regulations Committee on its deliberations on the Constabulary Force Act, amendment of 2nd Schedule Order 2021.
Reports from committees.
I'm going to try again. Mr. President, I beg to lay on the table of the Senate a copy of the report of the Regulations Committee on its deliberations on the Constabulary Force Act, amendment of 2nd Schedule Order 2021.
Notices of motions given earlier. Orally.
Early sometimes not so good, Mr. President. President, I am begged to give notice that at the next meeting of the Senate, I will move the following motion. Be it resolved that the report of the Regulations Committee on its deliberations on the Constabulary Force Act, amendment of 2nd Schedule Order 2021, which was laid on the table of the Senate on the 22nd day of October 2021, be adopted. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Public business.
Mr. President, I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
Those in favor? Those against? The ayes have it.
Mr. President, I believe that the matter is so clear and obvious that I don't think we will have a debate on the matter, Mr. President, and I would ask that the report be adopted, Mr. President.
The question is for the report to be adopted. Those in favor? Those against? The ayes have it. Minister.
Thank you, Mr. President. I thank you and I thank members for their understanding and granting Senator Braham the permission to table this matter. Mr. President, I now rise to present the Disabilities Regulations 2021. Mr. President, a disability is a common part of the human experience. Approximately 1 billion people, or 15% of the world's population, experiences some form of disability, according to the World Health Organization. Persons with disabilities include those who have long-term physical, mental, intellectual or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others, unless society, of course, rectifies the circumstances. Persons with disabilities are, as we have acknowledged on more than one occasion in this chamber and otherwise, Mr. President, among the world's most vulnerable. Unfortunately, they suffer disproportionately from poverty, unemployment, underemployment, and chronic health challenges. Barriers to full social and economic inclusion of persons with disabilities include inaccessible physical environments and transportation, the unavailability of assistive devices and technologies, non-adapted means of communication, and gaps in service delivery. Stigma, discrimination, and marginalization have also contributed to impacts on the lives of persons who live with disabilities. We note, of course, that women and children with disabilities are at an even greater disadvantage unless society intervenes, Mr. President. Mr. President, we firmly believe in the empowerment and socioeconomic inclusion of all citizens, and in particular, persons living with disabilities who are the subject of our discussions today. Jamaica has indeed made strides in the past 2 decades to promote the inclusion and protection of the rights and dignity of persons with disabilities. In the year 2000, the National Policy on Persons with Disabilities was approved in keeping with the United Nations Standard Rules on the Equalization of Opportunities for Persons with Disabilities. In 2007, Jamaica became the first signatory to the United Nations Convention on the Rights of Persons with Disabilities. We proudly joined the international effort to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities. And indeed, the fact that we were the first country is one oft celebrated, and indeed one noted by the role of Senator Morris, who was the Minister of State at that point in time, and I'm sure he will speak to us more on that as we take interventions later today. But it was indeed a proud accomplishment and one which we continue to celebrate today. In 2014, Mr. President, the Disabilities Act was passed to provide legal enforcement of the rights of persons with disabilities. And it must be recalled that the Act addresses the enjoyment of privileges, interests, benefits, and their treatment vis-à-vis other members of society. This is in keeping with the provisions of the UN Convention on the Rights of Persons with Disabilities. Mr. President, in 2015, Jamaica joined the world again in embracing the United Nations Sustainable Development Goals framework, that is, Agenda 2030 was promulgated, and 7 of those targets cover persons with disabilities. To achieve these goals, Mr. President, and this is a commitment of the government and I'm sure across administrations, we must empower people living with disabilities and remove the barriers which prevent them participating fully in society. Mr. President, regrettably, the operationalization of the disabilities framework has taken Jamaica, and indeed is taking Jamaica, a long time. It took more than a decade for the National Policy for Persons with Disabilities to be translated into the Disabilities Act, and it's also taking time for the Act to be brought into effect. We therefore all very much welcome, I am sure, across the aisle, welcome the fact that the Minister of Labour and Social Security has set February 14, 2022 as the date for the Disabilities Act to take effect. I would like to give the assurance to this chamber, however, Mr. President, that time has been taken since the passage of the Act to address some critical areas, including completing the organizational review and structure of the Jamaica Council for Persons with Disabilities, hereinafter to be referred to as the Council, as a body corporate in accordance with Section 5 of the Disabilities Act. This is a matter which is underway and will have been completed by February 14, 2022. Mr. President, the time has also included use to recommend and submit a structure of the Disabilities Rights Tribunal, a body to be established under Section 15 of the Act, and this is currently with the Ministry of Finance and Public Service for approval. The development of standard operating procedures, manuals, and codes of practice, Mr. President, to provide practical guidance to the public on the inclusion of persons with disabilities. Can advise that 3 codes of practice have been completed: the Employment Code of Practice, Education and Training, and Healthcare and Health Facilities codes of practice, Mr. President, and the code for public passenger vehicles will be underway shortly as the consultancy procurement is underway. Mr. President, identifying suitable accommodations to house the Council and the Disabilities Rights Tribunal has also been undertaken, as well as making preparations for the establishment of the confidential register and advancing the public education and awareness campaign. Consulting with stakeholders who assisted in the formulation of the policy that informs the disabilities regulations has also been an important part of this process. Mr. President, indeed, I can advise that a subcommittee was established by the Ministry comprising persons with disabilities and their representative organizations, including the Jamaica Society for the Blind, the Combined Disabilities Association, the Caribbean Christian Center for the Deaf, the Jamaican Association on Intellectual Disability, the Jamaica Association for the Deaf, medical practitioners, and other persons believed to be essential for the development of the regulations. This consultative approach not only assisted in the formulation of the policy, which informed the regulations, but also advanced the mantra of the disabilities community: nothing about us without us. Mr. President, the regulations are comprised of 15 provisions and 5 forms which are contained in the schedule to the regulations. I am going to go through and highlight some of the key regulations. The first, Regulation 3, establishes a procedure to be adopted by persons with disabilities to become registered as required by the Act. The procedure for registration is dependent on A, whether the person to be registered is a new applicant, or B, whether the person is already currently registered as a person with disability with the Jamaica Council for Persons with Disabilities, now a department of the Ministry of Labour and Social Security. An application for registration of a new applicant is to be made using Form 1. And Form 1 is to be accompanied by an eligibility report to be completed by a medical practitioner or specialist trained in diagnosing or treating the disability concerned. The applicable eligibility report forms are set out at Form 4. And of course, the eligibility issues differ by category. Mr. President, persons who are currently registered with the JCPD are required to apply to be registered using Form 2. These applicants are not required to submit an eligibility report in support of the application, as they are, of course, already registered and their eligibility will be taken to have been confirmed. An application is to be made, Mr. President, by a person with a disability or his or her caregiver, and the caregiver is defined under the Disabilities Act as a parent, legal guardian, or any other person responsible for caring for the health, financial, physical security, and general well-being of a person with a disability. The Council is required to review the application within 30 days of the date of submission or within such time as is reasonably practicable. And if the Council is satisfied that the person being registered is a person with a disability, it must issue a certificate of registration using Form 3 and record the particulars of the person in the confidential register. Regulation 4, Mr. President, provides for review of the decisions of the Council in 3 circumstances. So an applicant may seek the review of the following decisions of the Council. 1, it may seek to revisit the refusal of the Council to approve an application for registration by a person with a disability. It may ask for review of a non-renewal of a certificate of registration, or indeed for a decision to revoke a certificate of registration. Such an application is to be made within 21 days after the notice of the decision has been served on the applicant. And, Mr. President, the application is to be supported by the reasons that the applicant believes: A, the person is to be so registered; B, the certificate should be renewed; or, of course, the basis on which the certificate should not be revoked. The review is to be conducted by a panel appointed by the Minister, comprising a representative of an organization relating to the disability concerned, a registered medical practitioner, or a specialist trained in diagnosing and treating the disability concerned. And the peanut gallery to my immediate right, please. Thank you. Indeed, a representative of the Ministry with responsibility for health, nominated by the Permanent Secretary. Mr. President, the review by the panel is to be completed within 60 days after the Ministry receives the application, and if the review can't be practicably completed within the 60-day period, it is to be completed within such longer time as is reasonably practicable. The panel is to immediately communicate its decision to the Council in writing, and thereafter the Council is required to serve a copy of the panel's decision on the applicant within 10 days of receipt, and this period excludes Saturdays, Sundays, and public holidays. If the panel decides that the application for registration should be approved, then the Council must enter the particulars of the person with a disability in the register and issue a certificate of registration to the applicant. Mr. President, if the decision of the panel is that the certificate should be renewed, the Council is mandated to renew the certificate, and similarly, where the decision is that the certificate should not be revoked, then the Council is required to restore and indeed reissue the certificate. However, Mr. President, the period of restored certificate shall be 5 years from the date on which the certificate was originally issued. Regulation 5 deals with the validity of the certificate, Mr. President, and it provides that the certificate should be valid for 5 years from the date of issue unless it is revoked. And the certificate will cease to be valid on the death of the person with a disability. This I understand, on having raised the query, Mr. President, to not be unique to Jamaica. While there are some countries which have a 10-year certificate, there are others which have a 5-year certificate. And indeed, the 5 years is generally adopted in respect of children because of changing features and changing capacities. while whereas the same system, my apologies, has been adopted for children and adults to have a unified and predictable system, Mr. President. Regulation 6 provides for the application to review being made using Form 2, and it must be made at least 60 days before and not more than 6 months after the certificate of registration has expired. And if at the time of the application for renewal the person with a disability is diagnosed with a new disability, then details of the new disability are to be provided in the application. This is to be again supported by an eligibility report in the same Form 4, completed by a medical practitioner or a specialist trained in diagnosing or treating this disability. Mr. President, again, the Council is required to review the application within 30 days, and if the Council, within 30 days of receipt, and if the Council is satisfied that the person remains a person with a disability or has acquired a new disability over the past 5 years, then the application is to be approved and a new certificate issued. If the Council is not so satisfied, then the application is to be refused. The applicant is to be advised of the refusal and the reason therefore in an appropriately accessible format, and this notice is to be issued within 14 days of the date of refusal. Mr. President, Regulation 7 deals with the notification of a subsequent disability, and it requires a person with a disability or that person's caregiver to notify the Council in writing of any secondary or subsequent disability acquired after registration or renewal. And the information to be provided are the date or approximate date of the secondary or subsequent disability, that is the date on which it was acquired or confirmed, its nature and type. Mr. President, Regulation 8 deals with the revocation of certificates of registration, empowering the Council to revoke if it reasonably believes that the application for registration or any information submitted in support of the application is false or misleading. And the Council must provide the applicant with written notification of its decision in a format that is appropriate and accessible, and the Council is also required to provide reasons, and this is to be done within 14 days of the decision. Regulation 9 deals with the confidential register, Mr. President, and it speaks to the particulars that are to be kept in the confidential register. And the term, well, it includes the nature of the disability, Mr. President, which refers in the case of a congenital disability, a condition present at birth, and in the case of an acquired disability, a condition developed during the lifetime of the person with a disability. The term developmental disability, Mr. President, which also is addressed in the particulars, is defined as a group of conditions occurring during the developmental period of childhood, which lasts through the person's life and manifests in one or more of the following impairments: physical, learning, language, or behavioral. Mr. President, the confidential register is to be kept in the form prescribed by the Council, which may include an electronic database. The current electronic and manual database that is being used by the JCPD will be used by the body corporate to house the confidential register. And the confidential register will only be accessible to the Executive Director and employees authorized by him or her. The process to facilitate the employment of staff for the Council, including the Executive Director, is currently underway. In fact, it's being finalized, Mr. President. It should be noted that persons who are or have been employed by the Council are prohibited from disclosing any information contained in the register, save and except where the disclosure is required for the due administration of the Disabilities Act or where it is provided for under any other law. And, Mr. President, any person who discloses information in contravention of the regulations commits an offence and will be liable on conviction before a parish judge to a fine not exceeding $1 million or to imprisonment for a term not exceeding 12 months. Regulation 10, Mr. President, allows the Council to alter or correct an entry in circumstances where the Council verifies that the entry was incorrectly made, or in circumstances where information regarding the status of the person with a disability is provided to the Council after the particulars have already been entered in the register. Regulation 11 requires the Council to implement appropriate procedures to ensure that the information contained in the register is up to date, and the Council is also required to update the register where it's satisfied that a person with a disability has acquired a new disability. where the council is empowered to remove particulars of a person from the register where the decision has been taken to revoke or not renew a certificate, where the person is deceased, or for any other reason determined by the council in the circumstances. Regulation 12 empowers the council to issue a new certificate once it's satisfied that the original certificate was lost, stolen, or destroyed, and the new certificate will be valid from the date the original certificate was issued. Regulation 13 deals with the alteration of leased premises, and it specifies the form, that is Form 5 Part A, to be used in making the request for alteration. It also requires the lessee to provide a drawing, a plan or specification or other document prepared and signed by an approved building practitioner outlining the proposed alterations being requested. It is important to recall that Section 38 of the Act provides for the lessee to submit a written request in the prescribed manner to the lessor of the premises and to receive his or her written consent before making the alterations to the premises. The lessor must communicate his or her consent using Form 5 Part B, and members will recall that the Act provides that this cannot be unreasonably refused. And in the form, you will actually see that that language is placed quite prominently on the form so that the lessor will be reminded. Regulation 15 deals with the imposition of charges, Mr. President. It requires the Council to publish in the Gazette any charges related to its services. Members would be aware that Section 6 of the Disabilities Act empowers the Council, with the approval of the Minister, to impose charges for its facilities or services. And the services for which charges may be imposed include the applications for registration in accordance with Regulation 3, renewal of a certificate pursuant to 6, replacement of lost, stolen, or destroyed certificates in keeping with Regulation 12. Mr. President, the matter of disability is complex, and the interventions to overcome the disadvantages associated with disability are multiple and systemic. Such interventions require time for consultation and implementation, and we believe that this process has now been moved to a place where it can get off the ground successfully. I do trust that the community of persons with disabilities will be happier today now that this framework is closer to being operationalized, and it is my honor to submit these regulations for members' consideration and approval. I thank you, Mr. President.
Thank you, Minister. Senator Brown.
Thank you, President. In 2014, when I sat on that side of the aisle and we passed this Disability Act, it was done to protect the hundreds of thousands of people, of our brothers and our sisters who suffered from disabilities of one sort or another. I applauded as one who personally has a physical disability. So too did my colleague, Senator Morris. We applauded this bill because we knew it was a route to promote inclusiveness. It was a way to enhance the possibilities of people in the community living with disability to be successful in their many endeavors. And I'm sure then we cited a number of these people, and Senator Morris, since then there are others with disability who have excelled in our society. So then I thank the cabinet led by Prime Minister Portia Simpson-Miller for the courage and the effort to bring that piece of legislation forward. I thanked also the then chairman of the Legislative Committee of Cabinet, then Senator Mark Goulding, who worked dedicatedly, diligently to bring this legislation to Parliament. And he did it with the love conscious that his father had served the community of people with disability. So then Senator Mark Goulding really put his all into getting that legislation before Parliament and making it law out of the love that he had and all of us had to improving the life of people with disability. Then we praise Senator Floyd Morris for the numerous advocacy that he has led on this area. An advocacy which the minister has recognized has led you to be part of the UN committee today. But it must be an embarrassment to you to recognize that Jamaica, the first signature to the convention, is today without an effective legislation, one working for the people. And part of the reason why there has been this delay has been the absence of the regulations. Senator Morris, let me again thank you for all you have done. And you have, in the shadow cabinet, ceded to me the responsibility, through the leader, Senator, Minister, well, through the leader of the opposition, Mark Goulding, the responsibility for people with disability and special activities. So, I appreciate your continued guidance and support. And I know when you speak, you will speak much fully on the issues. Well, Mr. President, when we passed that bill in 2014, I knew that work had begun to put the codes in place, put the regulations in place, but then an event happened in 2016, February. And since 2016, February, this government has had the responsibility for completing the task of getting active a legislation that promote the best interests of the people living with disabilities. I recall, President, even without that legislation having the support of the regulations, you yourself, from the high chair of the Senate, spoke about doing something to allow for better access of people with disability to this, their chamber, because it is much their parliament as it is ours. And I'm waiting to see that action. I am sure your comment was made with good intention, and I wonder where's the lack of resource
Which comment was that, Senator Brown?
Comment where you made on the ascendancy of presidency about improving the access to the parliament for people with disability. And I'm saying you made it with very good intention. I am sure you have not been given the resources, along with the staff of the parliament, to make it a reality that whether members of the parliament or members of the public suffering from certain disability can really come, like everybody else, into our parliament. And that is a feeling that we all take responsibility for, not blaming anybody. We all take responsibility. I remember Bloomfield as he was, had an accident, but couldn't come to the parliament. So we're still where we were back then. And I hope that some effort now with the regulations will come resources to allow at least for the parliament to be inclusive in our relationship to people with disabilities. But it's also true, President, that not in my wildest dream would I believe that it would have taken 7 long years to bring the regulations into being. And that is why we are not going to be opposing them. We support them as an opposition. And Senator Leslie Campbell, I make a contrast with the debate we had earlier. The pandemic last year. Difficulties for the business communities to have annual general meeting. And look at the speed with which we accommodate business. Look at the speed with which we have accommodated business in bringing the amendment that they so wish, and they want more amendment. And I ask myself, why have we treated the people living with disability with such a slow boat to proper access? And it raises the question of where is our priority? How do we feel about the people with disabilities? And when we listen to the questions being answered this morning, questions posed by Senator Morris, it was clear that in the approach to data collection, we didn't put any priority on the people with disability. So the question is asked, how many persons with disabilities have been vaccinated? Answer, we don't have that data. The best they could tell us at one point is that they have written a protocol, but nobody knows what that protocol is. And it tells you of the lack of priority to people with disabilities, living with disabilities. So let me repeat it. When it comes to looking after the business class, we are fast lane. But when it comes to people with disability, we are like Shakari, dead last. And I want us to be like fast lane all the time when it comes to people with disability. Treat them serious, treat them with respect, show dignity, and look after their best interests. That has not happened. We do that for the business class, but we don't do that. I remember Senator Morris came here and raised a motion about access to school children living with disability. We got that motion approved. A Labor Day was announced. But post that Labor Day, as Senator Webley takes his exit, post that Labor Day, what has become of that initiative? Again, we have not treated the people living with disability with the seriousness and the earnestness that we show to them. And I hope that that will change and will change soon. I feared, President, that this Disabilities Act would have gone the way of the Protective Disclosure Act. Stillborn, dead at birth, dead at birth. I'm happy to see that the Minister of Justice and the Executive Director of the Integrity Commission have now said they're going to do some work on that piece of legislation. And they're going to set up a joint select committee to try and resurrect it. Because we believe in the resurrection of the dead. And if that giant select committee can be like Jesus and say, hey, Joe Lazarus, lie there, I'm going to raise him from the dead. Because that Protective Disclosure Act would be useful to a country where corruption is so rampant. It would be so useful. But thankfully, these regulations have come. And the Disability Act will not remain stillborn. There will be a resurrection. A resurrection, we're told, scheduled for the 22nd of February next year, 14th of February, 2022. 7.5 years after the birth of this legislation. We believe in miracles, and we will wait. Because had we been there, this would have been in place long ago, and the people would be better off. Flight would have made sure for sure. So my fear is that even these regulations, which will bring the resurrection of the bill, of the law, may suffer the difficulty we have with the Parliament, where we pass legislation. Great knocking on the desk, fanfare, good intention, but in reality we do nothing to enforce the legislations. We do nothing to enforce them. We just applaud their passing. And I'm going to address some of those afterwards. So I ask the government, while you set February next year, do everything in your power between now and February next year to get this law and the regulations up and running so we can give a new day, a better day to the people living with disabilities in our country. So I ask for alacrity. But Mr. President, I fear that while we wait, more people may fall into the category of those living with disabilities. Senator Hill, there are reports that polio vaccines are short and non-existent in the health system. Polio is one of the major causes of disabilities. Polio was the reason why Sir John Goulding came here. Polio was the reason why we set up the foundation at Mona. Polio vaccines is one of those vaccines that is mandatory. We must take it as children. They even have the little sweet syrup that make it more palatable. But we don't have it now. So more people may come down with polio and swell the ranks of persons with disability. So I want to make a plea to my friends in the cabinet, those sitting in the chamber and those outside the chamber. Please, on Monday, ask Minister Tufton where the polio vaccines. Please ask the Prime Minister, get it to the people as quickly as possible. We can't be talking about mandate of another type of vaccine, but the ones that we already mandate to stop people from becoming disabled is not available. Something has to be done about that. And President, allow me just to say this. It's not only the polio vaccine that is not available. As a newly minted granddad, I am aware that the BCG to deal with tuberculosis in newborn babies are not available. Not available at the University Hospital, not available at Maypen, not available at several public hospitals. If we measure a government by the way we treat the newborn, this is a failing government. If we measure a government by how they treat the newborn, this is a failing government. So I ask my friends and colleagues in the cabinet, solve the problem of vaccine unavailability. Post the absence of polio and the BCG. I ask you, work on that. Get it quickly to our people. Let us not increase those who are likely to become disabled because of absence of those. So let it be clear. We support vaccine on this side, you know. we support vaccine. Even the mandatory one for polio we support, though you don't have it. We may not support the mandatory one for the new thing. And the courts are dealing with that. So I won't be able to mention that now, since our case is in court and the president going to say, matters in court, don't go there. Not going there, Mr. President. But suffice it to say, we believe that the vaccines for polio and BCG should be made available to our people. And then there's another area in which we are failing that can create disabilities. I speak of the road traffic situation. A lot of the people lying in bed now disabled is as a result of motor vehicle accidents. 3 years ago, in this Senate, we passed the Road Traffic Act. The minister in charge of the government said, we need to deal with the indiscipline on the road. She wouldn't give a week longer in the debate to Senator Skeffrey, myself, Senator Knight, and others who wanted to put forward certain positions. We were told it had to be done in a rush. 3 years after, many more persons maimed because of the madness on the road and our failure to put in place the new Road Traffic Act and enforce it and curtail what is happening. And this represents a failing of this government, a failing to put in place the regulations. I hope those regulations will not be as long as 7 years as the Disabilities Act regulations. So I make a plea on behalf of the opposition to the government. Please bring the regulations for the Road Traffic Act so we may reduce the amount of people becoming disabled and dying on the road. I support Lucian Jones' call. Why is that act not there? And then I ask the question, what of the Building Act, which must go and complement this Disability Act? What is the government doing about those things? Clapping desks, passing legislation, but the legislation are not being put in action, not being enforced, not transforming the society. We can't be satisfied, Minister Hill, with just clapping desks. You know, that type of behavior is akin to using a 45-minute speech to promote one individual and to mention the name of that one individual in a 45-minute speech. That leads to what is called a cult, the cult of the personality. And I'm not going to Montego Bay. But the cult of the personality is as dangerous as His Excellency the Bishop. Yeah, man, a lot of people get kissed. And you know, I was there when she kissed you, you know. I was there when she kissed you in her office. So don't go to the kissing. But I'm glad Rubio didn't kiss you the other day. I'm glad Rubio didn't kiss you. So the applause we give and the banging of this when we pass this legislation is not enough. We have to go beyond that. We have to go to make sure we implement them. We have to go to make sure that they are effective and that we pass good law. And so this regulation will find our support. We're not going to go clause by clause because we can't amend them here. We'd hope that when you put them in place, after 7 years, we'll have a review soon of the legislation so we can look at the legislation and make the necessary adjustments. But suffice it to say, we are disappointed that it took you so long. We are glad that people like Floyd Morris have keep up the advocacy, including preparing to ask questions today again about this people with disability. We will never forget, we will never forsake the people living with disability. I am one of them. Floyd is one of them. So for personal reason alone, we will never forsake them. But let it be clear that we are not satisfied just with the tabling and passing of the regulations today. We will be actively pursuing the enforcement, the implementation of these legislation, because the people living with disability are, I know if I don't like this, are differently able. They are sufficiently able. They are as able as any one of us. They are so able that this morning in our caucus room, Senator Morris could describe the dress and shoe of every single one of the female members of our caucus. I might have exaggerated it, right? But the reality is, the reality is, Mr. President, that our people with disabilities are part of the assets of our country. We need to make them be inclusive in our relationship with them. We need to give them the opportunity to make progress and to contribute to the betterment of this country. The 2014 legislation was aimed at just doing that. Sadly, we have to wait for 2022. Is it on Valentine's Day?
Yeah, Valentine's.
For what we started many years ago. And if we learn a lesson...
Sorry, Senator Brown.
I understand.
Mr. President, it's now 1:20. I ask that the Senate be allowed to sit beyond 1:20 to finish the business of the day.
We should have heard the question that the Senate be allowed to sit beyond 1:30 to complete the business of the day. Those in favor? Against? Sorry, Senator Brown. Continue, please.
Yeah, well, I'm finishing. So I really want to express joy that the leg of the relay that you had to run, you have finally gotten over the disqualification bump. Because your leg really, really looked like somebody who was running with a hamstring problem. But you have handed over the tape, the baton. Let's together take that baton to new victories for people living with disability. May it please you, Mr. President.
Thank you, Senator Brown. Audley, you need a lectern? You need a lectern? Thank you, Senator Brown. Thank you, Senator Gill.
Thank you, President. You know, Mr. President, I spoke to my mother last night, and this Parliament, because when I spoke on the debate in 2014, I made reference to her 40 years of service in working with children living with disability. And I said to her that we're now at that very important stage where we intend to pass the regulations that would support that piece of legislation. And she said to me that it's all good and well when we pass these legislations and regulations, but most importantly is that we must promote a change in behavior as to how society responds to people living with disability. And I take that away because that's a critical and important focus. We can make policies, we can make legislations, we can make regulations, but if we don't change the behavior as to how people respond to those living with disabilities, we would have failed the society. And that's where I believe we need to focus. President, this is an important regulation. It is long overdue. And one of the things that we must do is that we must identify those issues that would prevent us from accelerating the passage of regulations in time, and to see if we can make the necessary changes. But we are here with this today, and I want to commend the minister and his ministry and the team who worked on it for taking it to this stage. It's important. President, this further promotes making persons with disabilities to be able to be involved effectively, and that they are included on equal basis with others in all aspects of national life. What it further does, it further promotes to have the right to education and training, the right to employment, the right to health care, and the right to housing and to enter premises. President, you know, the leader indicated that there are approximately 15% of the world's population, persons living with disabilities. And in all parts of the world, they are less likely than others that are not disabled persons to be in employment and more likely to be registered as unemployed. And I'm going there because I want, as a trade unionist, I want to focus on promoting employment opportunities for persons living with disabilities. Mr. President, they are more likely to be economically inactive, not registered either as employed or as unemployed. And thus, they are part of what you would consider to be invisible in the labor market statistics. When they are employed, they are more likely than the non-disabled persons to be unemployed, to be in low-paying jobs, have little access for promotions, prospects, and also in poor working conditions. There must be a focus for us to seek to try and change that. Mr. President, the concern must be reflected in the provisions on work employment policies to ensure the rights of persons with disabilities become a focal issue, that the state is obliged to concentrate on it. And Mr. President, we must recognize the right of persons with disabilities to work on an equal basis with others, and to safeguard and promote the realization of the right to work by taking the appropriate steps, among other measures. And what are some of these measures? We must prohibit the discrimination on the basis of disability with regard to all matters concerning all forms of employment. So someone comes for an interview and you recognize the disability, and the notion is there that this person can do the work. Yeah? How many times have they expressed the fear in even applying for a position in an organization because of their disability? And one of the important things is that we must start demonstrating and providing that opportunity by encouraging the promotion of employment of persons living with disabilities, starting with the public sector. By the very nature of that, Mr. President, we encourage the promotion of employment of persons with disabilities in the private sector, and for the private sector to have appropriate policies and measures that include affirmative programs for the employment of persons living with disabilities. President, I wish to suggest that the employment of persons with disabilities must be, and Senator Brown, you, if you wish, you can join me on this. It must be a topic of issue at the Labour Advisory Committee, where we can dedicate and develop and adopt some sort of comprehensive policy to improve the employment outcomes of persons living with disability. Mr. President, such a policy would recognize the diversity of this group. It would also recognize and accept that we must take a different principal approach towards labour market integration and labour market reform. We can't speak about labour market reform without mandating an objective in treating with persons living with disabilities. And given the concern I'm raising, and the concern that would have been raised by others, I think it's timely to review our operations and our systems to apply measures to promote employment opportunities for this marginalized group. Mr. President, in some countries, the consideration of a quota system is introduced that indicates that a defined percentage of the labor force is reserved for persons living with disability, especially if it's a large labor force. So let us focus on defining that quota and promoting that quota and have it established and implemented and entrenched in workplace policies. Mr. President, I am aware of one supermarket in Barbican that I visit sometimes. And that supermarket, it is noticeable where they employ persons living with disabilities. I commend that supermarket. And one of the things that I do is that whenever I need assistance in that supermarket, I go to the persons living with disabilities, because I want to ensure that their job is maintained. And so, we must encourage others, encourage other entities to take on that type of approach. The quota regime sometimes is something, Mr. President, we must adopt and effect not only in the private sector, but also in the public sector. And when the state demonstrates the action, it goes a very far way. We lead by example. And just like how in the regulation it has a requirement for registration in order to benefit from the quota provision, people with disabilities would generally be required to register as being disabled or to be certified following an assessment. Mr. President, another measure is for employers to protect the employment of persons who would have developed a disability based on an occupational injury, especially if it's partial. So you work at an entity and there's an accident at the workplace that would have created some sort of a partial disability. And the engagement is for some, well, let me see if we can have you some severance package. That's not going to help the worker, you know. It's not going to help the worker. The worker would have been impacted negatively by way of an accident, but the worker still has a life. And if we can afford ourselves the mindset where we can find alternative responsibilities to satisfy the need of that worker so that that worker can continue their working life within the organization, then we would have made marked achievements. And Mr. President, with that in mind, because accidents create disability, and we must intend to protect workers in their working life, I am once again calling for the passage of the occupational safety and health legislation. This cannot be another piece of legislation, Mr. President, that continues to be elusive to us. And so today, I am again making that call. President, we must also promote the acceptance of trainees and apprentices in our work programs as part of capacity building. So education and training is important. And you have young persons living with disabilities. And they too would want to be counted as part of the labor force. They have future objectives. And I called this morning, I spoke to the Heart Trust. And I said to a leader in the trust that as part of your training mandate, establish a quota for persons living with disabilities and have that quota as part of your strategic initiative and part of your balanced scorecard so that you are marked and assessed on that. Establish the quota so that it becomes part of your target. And once it becomes part of your target, it becomes part of your assessment. And so we can measure your performance on that. But the quota is very important. Mr. President, I know these provisions will not come as free. And as such, I'm recommending that employers who prescribe to these types of provision can be the beneficiary of some sort of employer incentive. If you do it, if you establish the quota, you sustain and maintain the quota, then there's some sort of incentive, and we can examine what those can be. They can come in the form of tax breaks, they come in the form of tax concessions. In some countries I've seen where the tendering process for public procurement preference is given to companies that meet some sort of a requirement and obligation. President, Jamaica is one of 6 countries that is classified on the quota system to have been introduced by a government decision by decree. And you have others that have a binding system with sanctions. So they put you have 33, that have a binding systems with sanctions. And some of them, another 64, have a quota system with no apparent sanction. And there's another 6 countries that is considering the quota. So we have declared, we are part of those that have declared the quota. The issue is that we must promote it and make it work. Promote it and make it work. Let it be part of an entrenched philosophy. And that is what my mother society views persons living with disabilities. Mr. President, I'm simply using this opportunity for us to promote employment opportunities and job securities for persons living with disabilities. And I don't want us to just come here today and declare the passage of a regulation and we don't speak about this again. It must be continuous debate. We must anchor our mindset that there is a need for continuous debate and deliberation about making provisions available for persons living with disabilities. And that's one of the things, that's one of the mandates in the Housing Trust, where they have allotted a quota in every scheme and every lot available for persons living with disabilities. And so if agencies that makes provisions take up these kind of measures, then we would go a far way as a society. And we must learn from these. And so there are examples out there, Mr. President, as to how we can promote, monitor, review results, but continue to make provisions for those individuals, those persons living with disabilities. And you know, one of the things that why we is because we don't know what it feels like to be disabled. Some of us, all you have to do is take off your glasses and read, and then you understand disability. You know, when it struck me about being disabled, what it feels like. I got chikungunya. And what would have taken me 15 seconds to walk a part of my house to get to somewhere in my house took me 15 minutes one night. That made me understand what it meant to feel disabled. And I know of persons who went downstairs in their house and couldn't go back upstairs. So we don't understand and yet to appreciate as human beings what others don't have, what others have to live with, what others have to feel for us to be able to make policies to assist them. But we don't have to feel it, President, we don't have to feel it to determine. We can just talk to them. They can relate. And so it is important also that when we are making and shaping these policies, we must involve them as important stakeholders. Consult with them. And so, Mr. President, as expected of me, I will continue this promotion. May it please you, Mr. President.
Thank you, Senator Gale.
My friend.
You're welcome, sir.
Thank you, Senator Morris.
Thank you. Thank you, Mr. President. Mr. President, I am beaming with joy today as I stand to debate the regulations on the Disabilities Act 2014. And I do so, Mr. President, by commending Minister Carl Samuda for taking the regulations to Parliament and setting the effective date for the Disabilities Act 2014 to come into effect on February 14, 2022. Mr. President, early in his sojourn as Minister of Labour and Social Security, I had a meeting with him to discuss matters relating to his portfolio, recognizing that I'm his opposition counterpart. And one of the things that we discussed was the implementation of the Disabilities Act. And he said to me, Senator Morris, if it is the last thing I do before I leave the Ministry of Labour and Social Security, I will ensure that the Disabilities Act is implemented. And I want to publicly commend him for insisting and pursuing the matter along with Minister Main for bringing this legislation to where it is at this point in time, notwithstanding the belatedness of its implementation. It is a piece of legislation that is long overdue, as Senator Lambert Brown pointed out. Mr. President, I also deem it with great joy, as I debate this regulation that is focusing on disability-related issues, that I handed to you and to the clerk and the leader of government business and the leader of opposition business in the Senate and the library of the Parliament, a copy of my third edited book, Inclusive Education, the Key to Social Transformation.
Senator Morris, you had given me a copy, and it was my intention on the motion for the adjournment to recognize the publication, and I will do so at the close of the adjournment in any event. But you have raised it, and I thank you very much for my copy.
You're most welcome, Mr. President. Mr. President, I raised it because it is a part of the effort to intensify a greater understanding of persons with disabilities, not just in Jamaica, but across the Caribbean and by extension the world, because within our region, within our country, there is a scarcity of data on the situation of persons with disabilities. And what I have sought to do through my work and my professional endeavors at the University of the West Indies is to push for a greater understanding of this marginalized population. And I will tell you, Mr. President, you are going to see in quick succession, by December, the fourth published book on the cultural inclusion, the cultural contribution of persons with disabilities to Jamaica. And it is, as I said, Mr. President, a part of the intensification of getting greater understanding of the population of persons with disabilities, and Senator Gale, to let people understand that persons with disabilities have been making meaningful contribution to the Jamaican society. And that is why when the publication come out on the cultural contribution of persons with disabilities, it's a mouth-wetting publication that, you know, is a must-read based on the peer reviewers' comments. So, Mr. President, I must say that, you know, I am very happy at where we are today in this debate to see the implementation of the Disabilities Act. It's a long journey, and we are inching closer. Mr. President, in 2007, Jamaica became the first signatory in the world to the Convention on the Rights of Persons with Disabilities, and the Minister mentioned it in her opening presentation. And for 5 years, Mr. President, I led the negotiations at the UN Convention on the Rights of Persons with Disabilities under the directive of the then Prime Minister P.J. Patterson, and in my capacity as Minister of State in the Ministry of Labor and Social Security. And I want to salute my partner then from the technical side, Mrs. Faith Inorarity, who worked diligently with me on the negotiations at the United Nations. And only in July, one of the chief technical persons at the UN was present at a special legislative conference in the region and indicated the role that I played in drafting and negotiating the Convention on the Rights of Persons with Disabilities, which has become the largest treaty body in the United Nations system, with some 184 countries as of today being signatories to the convention and 99 to the optional protocol of the convention. Significant. And this is a convention that governs, as Minister pointed, over 1 billion individuals with disabilities across the world, a significant portion of the world's population. The disabled population is regarded as the world's largest minority group. And I am very happy that Jamaica played a role in negotiating the convention, and the contribution that I could have made on behalf of my country and the people of Jamaica and the people of the world with disabilities. And I must say, Mr. President, that contribution and participation contributed to the significant respect that the world has for persons with for Jamaica when it comes on to issues relating to persons with disabilities. And this was manifest in the recent elections of persons to the Committee on the Rights of Persons with Disabilities that was conducted in November 2020, of which I was elected as one of the 18 experts on that August body. And I have already commended the government and the Ministry of Foreign Affairs and Foreign Trade for their role in the elections to that high office. Mr. President, my involvement in the codes of practice for employment and healthcare have been a part of the process in preparing for the implementation of the Disabilities Act 2014, because the parent legislation requires that the Jamaica Council for Persons with Disabilities establish codes of practice for guiding the implementation of the legislation. And Senator Gale, when you spoke, I made the sort of a share remark that you would have read the employment codes of practice, because some of the very issues that you raised are issues that have been established, formulated in the employment codes of practice, and will form a part of that where the employment of persons with disabilities are concerned in the future, because we recognize that there has to be an incentive program for private companies to stimulate greater employment of persons with disabilities. It is a clear and present danger where the inclusion and participation of persons with disabilities are concerned in the broader Jamaican society. And then we look at the issues relating to health care. For example, how do you treat persons with disabilities in the context of a pandemic? Those are issues that are highlighted there in the employment, the code of practice for health care. Mr. President, the regulation that we are debating today is very important to the legislative process, as it draws us closer to ensuring that persons with disabilities are included in the mainstream of the Jamaican society, and that they are not discriminated against. And we say, Mr. President, that time come for the discrimination to cease against persons with disabilities. Time come for the isolation and exclusion of persons with disabilities in the society to cease. Time come, Mr. President, for greater involvement, greater participation of these individuals in the mainstream of society. And we are committed to that process. And that is why, as Senator Lambert Brown indicated, we on this side unreservedly support the regulations. We reserve our right to express any concerns that we see where the regulations are concerned. That is what we are here as opposition for, to oversee and to review legislation, regulations, and policies that come to the House and the Senate. And I will be highlighting some of that shortly. Persons with disabilities are among the poorest within the Jamaican society, and indeed across the world. When you look at the data locally, certainly in 2015 we did a socio-economic study of persons with disabilities in Jamaica, and it showed 91.9% of the respondents indicating that they were unemployed, Senator Key. 91.1%. Significant. And that synchronizes with regional data and data from the World Health Organization that points to between 80 and 90% of developing countries' population being unemployed, and over 80% of these individuals living below the poverty line. And I want the members of this honorable House to Let that sink in, because I'm going to return to it in short order, because it is important for us to understand that when we are formulating regulation, legislation, and policies for persons with disabilities. The only places that we see significantly more employment for persons with disabilities than those of developing countries and in Jamaica is in developed countries such as England, Australia, New Zealand, Canada. And here we are seeing employment of up to 50% of the population of persons with disabilities. And a lot of these countries have a significantly well-entrenched and well-established social protection system for persons with disabilities. I was in a UN committee session in September where we reviewed a European country. And when I saw that they gave each citizen with a disability, hear this now, Senator Gale, Senator Lambert Brown, 800 euros per month. 800 euros per month for each person with disabilities. And this is irrespective of them being employed. When I did the conversion into J dollars, it was almost 150,000. The average person with disabilities is not even getting 30% of that in their earnings in Jamaica. And it means that we have a lot of work to do, and that is why, Senator Gale, your support for what is in the employment code of practice for incentivization of private sector companies for greater employment of persons with disabilities, and for the government to use its procurement mechanisms to employ more persons with disabilities is most welcome and appreciated, because we have to start the process now of implementation of the legislation. Time come for the legislation to be implemented. Time come for more persons with disabilities to be employed. Time come for more persons with disabilities to be educated. Time come for us to open up the Jamaican society for persons with disabilities. Mr. President, I want to point out something that is fundamental in the whole disability legislation and regulation sphere. Because you see, Mr. President, in my role at the United Nations Committee on the Rights of Persons with Disability, we operate also as a quasi-judicial body, because we have to oversee the implementation of the optional protocol, which gives individuals, countries that signs and ratify the optional protocol, there is an opportunity for individuals within those countries to take an inquiry to the Committee on the Rights of Persons with Disabilities, independent of the state. And so we have to adjudicate on those submissions. And it is a legal institution in its own right. And so I have been learning and understanding the legal ramification of some of the issues relating to persons with disabilities. And one of the things that I take note of, Mr. President, is that accessibility in the context of international law and disability law is treated as what they call an ex-ante duty, which refers to groups of individuals, persons with disabilities, and if the state is offering any service to the public, once there is a service that is being offered to the public, persons with disabilities have to be included even before they go to the government for any to take any complaint to the government or seek redress corrections on the matter. So what has to happen is that once a service is available to the public and you are a signatory to the Convention on the Rights of Persons with Disabilities, you must make sure that public services are accessible to persons with disabilities. It's a must once you're a signatory to that. And I'm going to now go into the concerns that I have and some issues relating to the regulation. And Mr. President, pardon me if I don't get the pagination correct, because I got a document that I couldn't access all the writings therein, and so that was a challenge for me, and I just need to have some further discussion with the team, who have been doing a very good job. I don't want to make much fuss with them about it. I mean, I think something might have gone wrong, but I just want to, some of the information came up as a picture, which never enabled me to access the information. So, Mr. President, on page 4, 141, it says, subject to paragraph 2, the certificate should issued under Regulation 3 shall be valid for the period of 5 years after the date of issue, unless revoked in accordance with Regulation 8. And 2, a certificate issued to a person with disability under these regulations shall cease to be valid on the date of death of the person. This latter point seems to conflict with the first, because the first is stipulating that a validity time frame of 5 years. However, the latter regulation is pointing to up to death. Mr. President, when I look at it, I'm wondering, why is it that the point about validity up to death is included there? Because if a person is dead, person can't use the certificate. I mean, nobody can even use it for the person with disability who is dead, because the information that is there on the database would have to match the identity of the dead individual. So I can't understand why that point is included there, Mr. President. On page 5, Regulation 6, which deals with the renewal of the certificate, speaks to fees that may be charged by the council. I strongly urge the government to review this matter carefully. Most persons with disabilities, as I've pointed out earlier, do not have the resources to pay for these services. They are poor people, and special consideration must be given to them. Mr. President, oftentimes you see a lot of these poor people on the road, on the streets, blind persons begging, people in wheelchair trying to eke out a living there on the street. And I don't understand how some of these individuals are going to pay for these registration in light of the fact that, you know, for you to access service from the JCPD, you have to be registered. And Minister, this is a policy matter that the government has to examine carefully. On page 6, this section deals with the refusal of an application. Point 2 states, within 14 days after the death of that refusal, within 14 days after that refusal, inform the applicant of the refusal in writing and in an appropriately accessible format, if this case so requires, giving the reason for the refusal. Now, when I saw the appropriately, there is the use of the term appropriately accessible format. And this gives the impression that the applicant would have a disability. In the context of this regulation, Mr. President, accessibility carries a particular meaning and is applicable to a person with disability. So, can I get some explanation, Mr. President, as to the use of this nomenclature, and why would there be a refusal of application to a person with a disability here? Because you're using the term appropriately accessible, which is indicating that the person would have had some form of disability. On page 9, the section dealing with the confidential registry 6, a person who is or has been employed by the council shall not disclose any matter contained in the register except as required under or for the due administration of the Disabilities Act or as for provided for under any other law. Does this take into consideration, Mr. President, research purposes? From time to time, individuals or institutions will apply for access to information from this confidential registry. Does these regulations allow for individuals who want to do research to access the information? And I'm very conscious of that because, you know, I'm a part of a research institution, and universities all across the island would want to be able to access information to conduct research on the population of persons with disabilities, which is a part of the mandate of the CRPD, Convention on the Rights of Persons with Disabilities, and also a part of the Disabilities Act. So I want to find out that in the context of this legislation. On page 10, this section dealing with the confidential registry again, paragraph 7, makes provision for penalties to be imposed for any violation in this section. and understandably so. However, I have asked about penalties for breaches to the designated parking spaces for persons with disabilities when the Building Act was being debated. However, I was told then that it would be better dealt with under the regulations for the Disabilities Act. But here, Mr. President, we have not seen anything relating to such serious violations that are taking place all over the country, where individuals who do not have a disability just park arbitrarily in these designated parking spaces. What is the government's position on this matter, Mr. President? On page 10, again, this section dealing with the update of the registry states the council shall remove from the register the particulars of a person with a disability and dash A, where a decision has been made to revoke the certificate or to revoke the certificate, not to renew the certificate, B, a person who is deceased, or C, for any other reason determined by the council. The registration of persons with disabilities based on these regulations creates the mechanism for services to be granted to these individuals. In other words, if you are not registered with the JCPD, then you will not be able to get access to the services. Save and except for the dead person, there can be no legal basis for the removal of the person with disabilities from the registry, as this is likely to be discriminatory and runs counter to the objects of the Disabilities Act 2014, and indeed the Constitution of Jamaica, I submit. Because what is going to happen once you remove the person with disabilities from the registry, it is going to deny that individual of an opportunity to services to the Jamaica Council for Persons with Disabilities, which is a state agency. And that in of itself constitutes, in my opinion, a discriminatory practice. And I can substantiate that further with arguments from the Committee on the Rights of Persons with Disabilities on Accessibility. On page 13, in Form 1, there is a set of documents that are cited for registration. These include NIS, TRN, and birth certificate. Is it that the person with disability must have all of them, or one is sufficient? I need to get some clarity on that, Minister. If, the person with disabilities have to present all of these documents upon registration, or it is just to get some form of identification for the person with disabilities. On page 20, there is Form 4, which deals with the eligibility report, and that's a number of other eligibility reports flows from there. At the top of the form it states, the purpose of this report is to provide verification of disabilities for registration of the Jamaica Council for Persons with Disabilities, JCPD, to receive the necessary support services for inclusion in Jamaican society. What this means, Mr. President, is that if you do not get this eligibility form completed, you will not be able to access the services of the JCPD. Further, persons with disabilities will have to pay the professionals to get this service done. This is burdensome for these poor and marginalized individuals with disabilities. I pointed out, Mr. President, and I said I want members to be aware of the data that I presented, that over 90% of these individuals are indeed unemployed. So where are these individuals to get the money from to go and pay professionals, whether it be medical professionals or individuals who are skilled professionals in their own area to conduct the assessment? Where is the individual with an intellectual disability who has never worked to get money to go and pay for assessment that is going to cost, in some instances, up to $100,000? Where is a little blind man going to get money from to go and pay an ophthalmologist to complete this assessment form when he or she does not have health insurance and a job to find over $10,000 to pay for the assessment? Where is the deaf person going to find the money from to go and get the assessment completed at the Jamaica Association for the Deaf or any other audiologist who will examine their hearing for the verification process? Mr. President, I humbly submit and make an appeal that where the payment for these services to the professionals are concerned, that the government should absorb the cost of this for persons with disabilities. And I know that there is the NIDS project that is taking place. This could be done through that initiative. Because, Minister, if you don't do it, you are not going to see an increase in the number of persons with disabilities on the disability registry. We have 30,000 people who are currently on the disability registry at the JCPD. And they have stuck at that for the past 2, 3, 4 years. And I have a strong feeling that a part of the problem that we have had with that is because a lot of these individuals, as a matter of fact, Minister, I will tell you that whilst I was on my talk show when I was on News Talk 93 FM, Senator Lambert Brown, people used to call me about it. And in fact, when we did the consultations on the employment codes of practice and the health care, this issue was raised in terms of the inability of persons with disabilities to pay for these services. And I tell you, Minister, I'm making the appeal to you to make sure that government takes a decision. There are some hard decisions that we'll have to take, Minister. You know, where persons with disabilities are concerned, but they are a part of the Jamaican family. And we are trying to bring them in the mainstream of Jamaican society. And these are poor individuals. And I feel the pain for these individuals because a lot of times the Center for Disability Studies is overwhelmed with individuals calling to speak to Senator Morris because they want to find out what is happening with this issue where disability is concerned. And for me, I have to tell them, I give them a listening ear, but can't respond, save and except to refer them to the Jamaica Council for Persons with Disabilities. But the Jamaica Council for Persons with Disabilities does not have the resources to deal with these issues. And I humbly submit that in order for this to be dealt with, adequate budgetary allocation has to be made to the Jamaica Council for Persons with Disabilities to ensure that on an annual basis, they target and get persons with disabilities registered. You don't have to do it. The government don't have to do it all at one in 1 year. We can structure it and subject it to what we call progressive realization. But I don't intend for us to make it languish for perpetuity. But I tell you, Minister, that if your government don't do it, the first call on a Mark Goulding-led PNP government is to correct this unjust practice, because persons with...
Mr. President, the Speaker's time having expired, might it be extended to allow him to complete his presentation?
Thank you very much. Members should have heard the question. Those in favor? Aye. Against? Senator Morris.
Thank you very much, Mr. President, and I won't be too long from closing. But, Mr. President, I say that the first call on a Mark Goulding-led administration is to correct that deficiency and make sure that persons with disabilities are not denied the services that are offered by the Jamaica Council for Persons with Disabilities, because as configured in the regulation, if these individuals don't get the professionals to sign off on their application and to verify that they have a disability, then they are not going to, the application is not going to be accepted by the JCPD, and these individuals are going to be denied the service. And so, Mr. President, I want to say that we support the regulations. And, Minister, you know, I don't say everything I must be involved with, right? But I've always made myself available to the government of Jamaica without fear of contradiction, because it's people with disabilities we're talking about, and I want to see the best for them. And I know that if I was, the first time I saw these regulations was when they were tabled in the Parliament. I wasn't a party to the drafting of these regulations. And some of these issues that I'm raising now, Minister, if I knew about them and how it is structured, I would have done everything to make sure that, you know, they are corrected. But I'm urging you, and I'm appealing to you, the President of the Senate, and to Senator Arbin Hill, and what happened to my friend Senator Matthew Samuda? He's not here today. Listen, man, why are you hiding me behind the thing? And Senator Campbell are part of the executive. Senator Cavan Gale, you are an influential member of the government. I'm making an appeal to use your good offices. Senator Goulding Campbell, you are also influential, making an appeal to have the government deal with the issues that I have raised, because they will only redound to the benefit of persons with disabilities. May it please you, Mr. President.
Thank you, Senator Morris. Minister? Senator Morris. Senator Samuda tricked you, because he was away and him just come back. So Thank you, Minister.
Mr. President, again, I rise today at the close of a debate to thank members of this Honourable Chamber for their contributions and for their positive commitment to ensuring the best results for the citizens of Jamaica from the matters which we put before, or rather which we take in these halls. Mr. President, I would just try to go through with some expedition and address questions raised most recently by Senator Morris. He had asked regarding paragraph 5.2 or regulation 5.2, why reference validity until death. It may seem a bit redundant, or rather a bit of stating the obvious, but it is not necessarily in conflict with paragraph 1, as there is provision elsewhere for renewal of the certificate. So it's renewed every 5 years and then ceases, of course, to be renewable on death. So it may seem a bit to state the obvious, but it is there, and as we have noted, as it does no harm, then it is, of course, retained. On the matter of charges to persons who apply, certainly the Act provides for it, and therefore the regulations provide for it. But it does, in fact, say that any charges would be as the council may determine, and the council, of course, would provide its recommendation to the minister. And I would imagine that there would be sensitivity, although this is provided for. So it's in it's in section 6.2c of the 2014 Act, which you had passed, and the regulation provides the exact same language as set out in the Act, but it is a power that resides with the council, and accordingly the council will make its determination in that regard. And I do trust that the council will be sensitive to the issues which we are all aware must be considered when in the context of the policy intent of the law, which is to provide for inclusion. The question of accessible format on refusal of a certificate, the language may seem counterintuitive perhaps, but it is a language that was generally being used throughout the Act. So while your point is taken that it may presume that needing accessible format would be indicative of a disability, the fact is that the provision of the ability to use different formats is not necessarily it's not negating the decision that would have been taken, which one would presume would be on substantive grounds. And I would just at this time take the point which you had raised in respect of 11.3, which was about the ability to remove. So the ability to remove from the register certainly would not be intended to be undertaken in circumstances of discrimination. So far as I understand it, the point is that persons may have a disability and be entitled to register, but that disability may not be permanent. And accordingly, when their circumstances change, they would be eligible for removal from that register. And certainly, if technology were to change, treatment were to change, and allow for disabilities to be overcome, what is defined as a disability today may not be tomorrow or 5 years hence. And this is why the issues of revocation and renewal have been provided provided for, not to implement as a tool of discrimination, but to ensure that persons would not seek to benefit from services to which they are not entitled. And that is the only provision there for completion and not for discrimination. On the matter of the Form 1, you had asked whether NIS, TRN, and birth certificate are all required. Yes, they are on an initial registration, as they are required for any formal national registration in any circumstance. These things are required. And this is why we have, of course, been advocating for a simple way, simple national identification that would not require persons to have all of these things provided. I anticipate that in due course, therefore, these matters will be simplified when we have taken other legislation which has now been put before us. I believe that those were the other questions. The matter of the, the charges on completion of the form, the eligibility form. There is no charge for this where it's undertaken in the public health service. So while a private practitioner would be likely to charge, where these forms are filled out by medical professionals within the public service, then there is no charge that is attached. So it is not anticipated that this will prove to be an inhibiting factor in implementation. But it is a good question because, of course, one would want to know that this is what I've been told. I can only take the instruction that's given to me by the technical person. I'm not the line minister. So, Well, I presume that the team is hearing, and I don't see, I'm hearing that that is not the case, that it is working. People are using the health system to get their forms and to get their, not this form, but their registrations completed now. And I anticipate, and I'm sure you hope, as well as we do across the aisle, that upon the promulgation of this legislation, of these regulations, and upon enhanced public education, and I've been seeing some of the material that's been developed, and it is intended to ensure that there is practical information available for businesses, homes, landlords, and otherwise for them to implement accessibility tools, as well as to understand the actions that we all need to take as a society in order to provide for the truly just and inclusive society to which we all work, or for which we all work. And on that note, Mr. President, I just want to affirm the commitment of the government of Jamaica to creating, to the goal of creating an inclusive and enabling society for all Jamaican citizens. We believe that belonging and participating equally among all of us in living, learning, and working, that this will be facilitated by the Act coming into force next year, supported by the regulations and the other efforts which are underway. So I want to add my congratulations and appreciation to the Minister of Labour and Social Security, who is driving the forces now to bring the Act into effect, to thank those which have come before him and contributed to the process, to thank the officers involved in the development of the policies and the legislation, as well as all stakeholders. And I wish in particular to thank and express appreciation to the Jamaica Council for Persons with Disabilities in particular for their work thus far to advocate for and empower persons with disabilities and their families, as well as their work to ensure that individuals and businesses become more aware of how to make our spaces more inclusive. And the Executive Director, Ms. Hendricks, is here with us today, so we welcome her as well as part of the supporting team. Mr. President, I want to thank the members of the public and private sectors and the non-governmental organizations who participated widely in island-wide consultations on these matters and who gave up their time freely on these issues. And in fact, as we speak about accessibility and just recognizing how important it is, I just wish to recognize that one of the benefits of having moved to the new building at the Ministry of Foreign Affairs and Foreign Trade is that we are fully accessible, which we were absolutely not at 21 Dominica Drive. We now have ramped access, we have braille-enabled elevators, the outer buttons are all indented. We have access at the levels and floors which allow for ease of movement of wheelchair and any other constrained movement. And it is really just such a massive improvement in seeing how things can be done. Recognizing that retrofitting is an entirely different process and can be far more difficult, far more expensive, and deliver less optimal results than where you are starting from scratch and you're able to say this is what will work best. You lay out the plans, etc. So we do hope that developers, public sector builders, persons who are in the construction industry will be more alive and more sensitive to the requirements of accessibility when as we continue to build and develop Jamaica. And this is something to which we are all committed. So again, I thank members for their contribution. I thank the team for their support and all of their efforts in getting us to this very important juncture. And I know we are all looking forward to February 14, 2022, which will be the next crossroads. Everything clearly won't be solved on that day, but it is going to be another springboard for ensuring that we deliver this inclusive and just society which we all seek. So with that, Mr. President, I ask that the regulations be approved.
Thank you very much, Minister, and also thank you to the persons who participated. And the question is that the motion put forward by the Honourable Minister be approved. Those in favour? Against? Ayes have it. Minister.
Thank you, Mr. President. Mr. President, I am not aware of any further business that needs to be done today. I am just making sure that there is nothing that has slipped my schedule. And it seems like this is it now, Mr. President. So I would wish to ask that the Senate be adjourned for a date to be fixed.
Thank you very much, Minister. As I indicated earlier, I was presented with this marvelous publication by Senator Morris, who, as you all know, is the director of the University of the West Indies Center for Disability Studies and one of the 18 expert members of the United Nations Committee on the Rights of Persons with Disabilities. And you all would have recalled that his elevation to that position was, I think, earlier on this year. But the publication, Inclusive Education, the Key to Social Transformation, is, I think, the third published book by Senator Morris. And those of you who are interested in the topic, I would certainly advocate that you secure a copy of this publication. And for those of you like myself who still have their first publication in their brain, I certainly advocate that you take a leaf out of Senator Morris's book, as it were, and begin to contemplate putting your thoughts in print. Thank you very much. Thank you, Senator Morris, for the copy of the book which you presented to the Library of the Parliament, and to the clerk. I thank you on behalf of the clerk, and no doubt in years to come Thank you very much, members. The question is the Senate be adjourned for a date to be fixed. Those in favor? Against?